Hello to everybody and welcome to the UFMG Constitutionalism and Democracy Seminar Series. I am Tima Adrinozzi, visiting professor at the Federal University of Minas Gerais, and I organize these events with my colleague Emilio. Hello to everybody and welcome to the UFMG Constitutionalism and Democracy. So the seminar series are an initiative of the graduate program in the law of the Federal University of Minas Gerais and the Digital UFMG Content Governance Research with the support of the UFMG Study Center on Transnational Justice and UFMG GNet Research Group, the UFMG Center on Transnational and Comparative Juridical Studies, the Untitled Chapter Brazil, the graduate program in law of the Federal University of the Semi-Arid, the graduate program in law of the Federal University of Berlândia, University of Brasilia, and the Brazilian Association of Political Philosophy and Constitutional Law. Although the results of the presidential elections in the United States indicated a point of constitutional resilience, the worldwide trend on democratic and constitutional erosion is still in place. Against this background, the seminar series on constitutionalism and democracy aims to create an online forum of topical, vivid, and interactive academic debate. This series of events provide opportunity for distinguished emerging and early career scholars to discuss the main concerns and challenges affecting the current constitutional jurisdictions around the world from the perspective of comparative constitutional analysis. We have already discussed many important and actual topics, which are available on the YouTube channel of the postgraduate program of our school. Today, we have the honor to host as keynote speakers Professor Rosenfeld from the Benjamin and Cardozo School of Law at Yeshiva University and Professor Cólon-Rios from Victoria University of Wellington. To act as a discussant in this panel, we are pleased to welcome Professor Faraguna from the University of Trieste. Let me quickly proceed with how the format of this event today will look like. First, Professor Cólon-Rios will explain how he sees the relationship between democracy, constitutional identity, and historical constitution. And then Professor Rosenfeld will talk about the relationship between constitutional identity and populism. They will have more or less 20-25 minutes. After this, our discussant will have like 10-15 minutes. After that, we will have a Q&A session in which the audience can make comments and ask questions. Please, for this, use the chat function. I would like to thank our team, Ulysses, Anna Luisa, Bruno, and Natasha for helping us in the organization of the series. As usual, we are recording this panel. If you disagree with that, please turn off your cameras. Dear speakers, thank you very much again for accepting our invitation. I also would like to welcome the audience. Thanks for joining us today. Professors Rosenfeld and Cólon-Rios, I'm looking forward to your presentations, mainly because, if I'm not mistaken, both of you will use Hungary as an example. And as a Hungarian who has also done some modest research on constitutional identity, I am curious about what you see when looking at our constitutional system and identity, and what your views are about constitutional term of the historical constitution used by the Hungarian fundamental law. I'm also wondering whether Professor Faraguna, if he will have some time, could bring the supranational perspective into the discussion, as the constitutional identity of the EU seems to be a concept on the rise. Thank you again. The virtual floor is yours, Professor Cólon-Rios. Thank you.
Thanks very much, Timia, and thanks to Professor Neddermeyer and of course to you as well, Professor Drinowski, for this invitation to address you today, and also for the opportunity to discuss these issues with Professor Rosenfeld and Professor Faraguna. And thanks also to all of you for being here. I must begin by saying that I am a sort of outsider to discussions of constitutional or about constitutional identity, in the sense that I have not really written about constitutional identity as such, even though I frequently refer to it in the context of work about constitution making, about the doctrine on constitutional amendments, and about the theory of constituent power. And you will see that my intervention today reflects that outsider kind of approach. So what I would like to do is to offer three main observations about what I will call the descriptive and normative dimensions of the notion of constitutional identity. First, I will argue that from a descriptive perspective, the notion of constitutional identity largely expresses the same idea as the centuries-old doctrine of the historical constitution. Second, I will argue that, like the doctrine of the historical constitution, the notion of constitutional identity will usually entail an inherently conservative approach to constitutional change, and that as a result, it may find itself at odds with a democratic conception of constitutionalism. And I will end with a reflection of what I think the democratization of the notion of constitutional identity would require. So let me begin by saying something about the descriptive and normative dimensions of constitutional identity. I think that academic engagements with this notion are, at least at first sight, of an entirely descriptive nature. For example, Gary Jacobson has associated constitutional identity with what he calls the defining attributes of a constitution. Those attributes are contestable and they are subject to interpretation, but the point is that their replacement would transform an existing constitution into a different one. The replacement would amount to a change in constitutional identity. Now, those defining attributes may relate, for example, to fundamental principles such as democracy, the rule of law, the separation of powers, secularism, federalism, or to the protection of certain fundamental rights or of a particular form of government or a particular type of socio-economic regime. Scholars often argue that the replacement of one of the Constitution's defining attributes lies outside of the jurisdiction of the amending authority. In doing so, they sometimes appear to assume a normative perspective, one according to which the identity of a constitution is something that ought to be protected. For example, Professor Rosenfeld asks whether, and I quote, there can be any cogent way to determine at what point do constitutional amendments threaten to destroy constitutional identity. Now, although the language of threat and destruction may be understood as having a normative connotation, I think that scholars who write about constitutional identity, including Professor Rosenfeld, do not really argue that the identity of a constitution should always remain untouched. And in fact, they frequently suggest that constitutional identity is constantly undergoing processes of reconstruction and renegotiation. One can nonetheless find, for example, statements like the following, made by Jacobson in the context of a discussion of Edmund Burke's work. I'm quoting from his paper. He says, the identity of a constitution represents an amalgam of generic and particularistic elements consisting of certain attributes of the rule of law that are the necessary condition for constitutional governance. He also notes, and I quote, that imagining a polity in which the left hand of the present was the sole source of direction for its collective choices is to imagine a polity without a constitutional identity. And this suggests a kind of normative approach according to which there is a certain type of content that must be present or certain arrangements that must be ruled out as one in which present generations are the sole direction of collective choices in order for there to be something worthy of the name constitution, something that can have a constitutional identity. But despite those kind of approaches or statements, the normative conception of constitutional identity is much more clearly reflected not in academic works, but in judicial decisions involving the doctrine of unconstitutional constitutional amendments. In those cases, courts see themselves as preventing political actors from transforming the existing constitution or the existing constitutional identity into a new one. Consider, for example, the famous dictum of the Supreme Court of India in a 1980 case, and I quote, the Constitution is a precious heritage, therefore you cannot destroy its identity. This kind of idea is sometimes presented as a means of ensuring that the legislature's amending power does not become supreme over the Constitution and over the court itself. For example, the Indian court has expressed that if Parliament was understood as having an unlimited power of amendment, it would become an authority above the Constitution because it would have the power to alter, and I quote, its basic structure and even to put an end to it by totally changing its identity. This is also the kind of approach embraced by the Colombian Constitutional Court, which has expressed that the exercise of the power of constitutional reform should conserve, and I quote, the identity of the Constitution. Accordingly, the court has stated that changes that would, for example, involve the replacement of the social and democratic state and the republican form of government with a totalitarian state or with a dictatorship would be outside the competence of the amending authority. Okay, so that's what I mean by the descriptive and normative dimensions of the notion of constitutional identity. Now, my second point is that constitutional identity has strong similarities to, and to a certain extent reproduces, the doctrine of the historical constitution. This doctrine was highly influential during the 18th and 19th centuries, particularly in Spain, and continues to be part of the constitutional discourse of some jurisdictions, as we will see soon. According to the doctrine of the historical constitution, each society is governed by a set of fundamental norms that develop through history and that reflect the way of being of the community in question. In Spain, its main proponent was Gaspar Melchor de Jovellanos, who died shortly before the country adopted the Constitution of 1812. Now, Jovellanos' understanding of the historical constitution is probably best introduced through a discussion of his conception of the right of resistance. So according to Jovellanos, Jovellanos' conception of the right of resistance, this right shares some important features with Emmanuel Sieyès' concept of constituent power. So the right of resistance for Jovellanos is extra-legal, inalienable, and supreme over any constitution. It was, he says, and I quote, a power superior to any other power derived from the Constitution, an original and primitive power immediately derived from nature itself. But Jovellanos' view of the right of resistance is in fact directly or negates in an important way the idea of constituent power. Because for Jovellanos, when a nation exercises its right of resistance, its task is not to create a new constitution, like in an exercise of constituent power, but rather, akin to someone who has been tasked to deal with an emergency, what the nation would do in exercising the right of resistance is to restore the constitution that has been violated by an oppressive government. In other words, the nation would protect constitutional identity. Now, this view follows from Jovellanos' conception of what a constitution is, which was a conception similar to the one defended in pre-revolutionary France by supporters of the traditional monarchy. So he said that a constitution was simply the fundamental laws that fix the rights of the sovereign and the subjects and the healthy means of preserving both. And he called these fundamental laws the effective or historical constitution. And then when asked, where do you find these fundamental laws? He says, and I quote, "We found them in our old codes, in our ancient chronicles, in our depreciated manuscripts and dusty archives." Now, since the historical constitution was formed slowly through the ages, Jovellanos thought, and I quote, that to think that a constitution can be made just in the same way that someone writes a play or a novel is a great insanity, he said. Accordingly, he insisted that not even the nation had the right to alter the form and the essence of the historical constitution. Now, that view, of course, was precisely the view that was rejected by CS and others during the French Revolution. In fact, what they argued was that France did not have a constitution, just in the same way that some theorists claim the same of England. But Jovellanos thought that CS and his followers were wrong, because France and England did have an historical constitution, and a similar one at that. That is, a constitution based on a set of fundamental laws according to which the monarch and parliament shared sovereign power. Now, this is not simply like a theoretical approach about what a constitution is, but it was an approach that was actually defended and defeated by some members of the Constituent Parliament that eventually adopted the Constitution of 1812. So, for example, Pedro Inguanzo Rivero, who defended the traditional monarchy, claimed, and I quote, this is at the debates, at the debates of the Constituent Parliament, he said, there are laws that, because of their nature, are unalterable in any event, and others that, on the contrary, can and should be changed at different times and circumstances. To the first type, Iwanso added, belong those laws that are called and are truly fundamental, which constitute the basis of the state, and if destroyed, the entire social edifice would fall. All the others belong to the second type. Now, this approach bears some important similarities with that of Edmund Burke, which, as you will remember, I mentioned in the context of Jacobson's work on constitutional identity. Like Jovellanos, Burke rejected the very idea of someone having the authority of giving society a new constitution. No one could legitimately claim to possess what French revolutionaries had called constituent power. So Burke expressed alarm that the French Constituent Assembly had no fundamental law, he said, and he despised the idea that the members of the Constituent Assembly, and I quote, claim to have the power to make a constitution which shall conform to their designs. The very idea of the fabrication of a new government, he wrote, is enough to fill us with disgust and horror. A constitution could, of course, be reformed, but only with attention to what Burke called the principle of reference to antiquity. So like Jovellanos, he thought that the spirit of the Constitution was to be found, and I quote, in our histories, in our records, in our acts of parliament, and journals of parliament. This did not necessarily mean that revolutions were never justified. For example, the Glorious Revolution of 1688 for Burke had a clear justification because it had the purpose of, and I quote, preserving our ancient indisputable rights and liberties. It was a manifestation, in other words, of the right of resistance as properly understood, that is to say, as understood, for example, by Jovellanos. Okay, so the doctrine of the historical constitution and the notion of constitutional identity are both ultimately about protecting somehow a hard core of constitutional content, at least that normative notion of constitutional identity. Now, the modification of that hard core would give rise to a new constitutional order, as it would have destroyed a set of principles and rules that aspire to be permanent. It is in that sense not surprising that in those rare instances in which the doctrine of the historical constitutions makes an appearance in contemporary constitutional discourse, it usually appears together with the notion of constitutional identity. So here are two examples. In 2001, the Peruvian Congress passed a law assigning a congressional commission the task of drafting a new constitutional text. The process never took place. Now, in its Article 2, the law established, among other things, that the drafting commission shall propose a total reform of the constitutional order, taking, and I quote, into account the historical constitution of Peru. When the constitutionality of that process was examined by the Constitutional Tribunal, the court defined the phrase total reform as a situation, and I quote, where the hard core of the Constitution or the historical Constitution, as the challenged law states, is altered even if not all the articles of the current constitution are modified, end quote. At the same time, the court maintained that the ordinary amending power was subject to, and I quote, the parameters of constitutional identity or essence immune to any possibility of reform. So you see historical constitution and constitutional identity together. The second example involves the fundamental law of Hungary, adopted, as you know, in 2012. In its preamble, as later amended, the fundamental law states, and I quote, "We claim that protecting our identity as it is rooted in our historical constitution is a fundamental duty of the state." And in Article R, the fundamental law states that constitutional provisions shall be interpreted in accordance with the achievements of our historical constitution, and that every organ of the state shall be obliged to protect the constitutional identity and the Christian culture of Hungary. Now, interpreting some of these provisions, the Hungarian Constitutional Court has stated that, and I quote, "The constitutional self-identity of Hungary is not a list of static and closed values, although it includes the division of powers, republic as a form of government, respect of autonomies under law, the freedom of religion, parliamentarism, the equality of rights, and those values the court expressed are, among others, the achievements of our historical constitution. The fundamental law and thus the whole Hungarian legal system," the court said, "are based upon them." Once again, the idea is that there are certain fundamental principles, a certain constitutional hardcore that is, or should be, at least in some way, protected from change. So there is, at the very least, a very close conceptual relationship between the doctrines of the historical constitution and the notion of constitutional identity. So why is this important, or why is it a problem? The problem, I think, is that the notion of constitutional identity, like the doctrine of the historical constitution, is not simply inherently conservative, which is not necessarily a bad thing, but if not clearly distinguished from the doctrine of the historical constitution, constitutional identity, or the notion of constitutional identity, runs the risk of also being inherently undemocratic. Now, what I mean by this is of course not that the notion of constitutional identity is incompatible with the existence of a democratic constitutional order, or that a democracy cannot operate if the constitution is conceived as having a hardcore that is somehow protected from change. My point is rather that such a notion must be complemented with a democratic view of constitutionalism. Under that kind of view, a change in constitutional identity, while foreclosed to the ordinary institutions of government, should always be within the reach of a citizenry that is able to act and to reflect about and to alter the fundamental principles in which the constitutional order rests. And it should be able to do so through formally regulated participatory mechanisms of constitutional change. Otherwise, the notion of constitutional identity as the doctrine of the historical constitution can become a conceptual tool to justify the existence of juridical forms that at a particular moment in history, say 2022, are determined to be the correct ones. Fortunately, and despite their similarities, there is a way of differentiating between these two notions. And the distinction has to do with a key element of the doctrine of the historical constitution, that constitutions should not be understood as something artificial, something that can be made and remade. That view, I think, can now be confidently described as anachronistic. As Professor Rosenfeld has stated, and I quote, "Ever since the American and French revolutions of the late 18th century, constitutions are conceived as fundamental charters that a people give to and impose on themselves. In a nutshell, while the doctrine of the historical constitution rested in an implicit rejection of the theory of constituent power, the notion of constitutional identity is, or at least can be made, consistent with it. Indeed, during the French Revolution, the history of the theory of constituent power provided the legal justification for the abolition of key institutions of the French monarchy, and eventually of the monarchy itself, that is, for the replacement of France's historical constitution or France's constitutional identity. Not surprisingly, proponents of the doctrine of the historical constitution explicitly rejected the theory of constituent power, not only in France, but in Spain as well. So, for example, once Fernando VII was brought back to the throne and the Spanish Constitution of 1812 was abrogated, the constituent parliament that had adopted it was denounced for having, and I quote, introduced in Spain the subversive and impious ideas of the French Revolution, totally alien to Spain's national tradition. Now, that the notion of constitutional identity, unlike the doctrine of the historical constitution, can accommodate the theory of constituent power is exemplified in contemporary judicial practice. In fact, both in Colombia and Peru, which I mentioned earlier, constitutional courts presented the notion of constitutional identity as part of an account of democratic constitution making. For both courts, the constituent subject is always able to change the identity of the constitutional order. However, my point here would be that it is not enough to say that. It is not enough to say that of course, constitutional identity can be changed through an exercise of constituent power, as those courts did. Rather, I think that the constitutional order must provide a means for the citizenry to periodically or episodically deliberate and decide on those fundamental aspects of the constitutional regime. And if those mechanisms are not available, then there's little that would distinguish in practice between constitutional identity and the historical constitution. Both would be about identifying what is considered at a particular moment in time constitutional content that is okay, even if it is consistent, for example, with extreme levels of economic inequality, environmental destruction, and so on. Now, what those democratic mechanisms would look like is outside the scope of my intervention today. However, I think that they would have to go beyond the mere possibility of having a constituent assembly or a constitutional convention convened by the legislature. They should, for example, include the possibility of triggering constitution-making processes by popular initiative, as well as local or primary assemblies that deliberate about the fundamental principles that a new or radically transformed constitution would seek to realize. So that is what I had to say, and I look forward to Professor Rosenfeld's presentation and to your questions and comments.
Thank you very much. And now I would like to invite Professor Rosenfeld.
Thank you very much, and thanks to the organizer for inviting me to this discussion. And my subject is different than the one just presented, but to anchor my discussion, which is the question of populist constitutional identity as opposed to liberal democratic constitutional identity, let me reiterate that my view of constitutional identity is a dynamic dialectical one. So it doesn't stand for either tradition or revolution or anything like that. The basic idea is that in order to have a functioning constitutional system, and it can be a very conservative one, it can be one like the British idea of the Constitution building itself and evolving through millennia, or it can be, as already mentioned by Professor Cólon-Rios, the French Revolution and the American Revolution, which some have characterized as a creation of a constitution ex nihilo after overthrowing the existing legal order. My theory is neutral as to whether it's a conservative, a progressive, a revolutionary, or any other kind of constitutional arrangement. What my theory explains and tries to provide is the idea you cannot have a functioning constitutional order unless you have a constitutional identity. And the constitutional identity is that of an imagined community, just like national identity. It's a creation. It's a narrative that we give ourselves in order to function. Of course, we change the narrative all the time, and we can use, as I said, conservative and progressive and even revolutionary discourse in how we proceed with it. The specific problem that I am addressing today is what about populism and illiberalism? We had, I think, those of us who have practiced in this field for a very long time, and I see many younger colleagues around, this may not be your vice, but it was my vice, and many of those of my generation, is to have assumed that constitutional democracy, liberal constitutional democracy, particularly what happened after World War II, when Germany turned to constitutionalism, when Spain and Portugal abandoned their dictatorship, when the Soviet Union disintegrated and countries like Poland and Hungary jumped into the constitutional fray, South Africa, etc. A long list of, after the dictatorships in Latin America, we were all heading to a world where constitutionalism was predominant. And there were, of course, different iterations, different arrangements, but it had four pillars. It involved the limitation of powers, adherence to the rule of law, protection of fundamental rights, and some guarantees of democracy. And so the populist challenge and the liberal challenge, which are of more recent vintage, are saying we can be totally within constitutionalism, but we don't agree with liberalism. And so on the one hand, there's been a dichotomy between liberalism and authoritarianism. So we understand when people say that liberalism and liberal democracy does not work. Xi Jinping and Putin seem to be clearly in that camp. But what we have, and this is why I chose Hungary, and I hope in front of my Hungarian host I don't make a fool of myself. I've spoken about this in front of other Hungarian scholars, and they were polite enough not to run me out of the room, but so I hope that you will be indulgent too. The idea of Viktor Orban is that he decided to change the constitution and keeps writing that he is operating completely within democracy and the rule of law. And so while he rejects checks and balances, which is an American phrase, he says, I'm subject to election and re-election. And when I wrote the paper that I circulated, his last victory was in 2018, but now we can add that he has one more victory and a very spectacular victory. Although if we look at how the electorate breaks down in Hungary, as it does in many states in the United States, is that you can get minority vote or a very small majority, and it's blown up because of the way that the democracy is organized. So my question, therefore, is in terms of building identity, is there anything inherently different between a populist, illiberal version of constitutional identity and a liberal democratic one, or they use the same ingredients, and of course the details are different, but the same process takes place. And my task that I give myself is complicated by the fact that any constitutional identity, as I conceive it, requires basically three interpretive modes. You have to try to give a coherent view of your constitution. In this sense, creating national identity and creating constitutional identity are similar processes. You have to invent them, but you have to invent them in a way that's convincing for enough people that they're workable. And so if a person in a dark room by him or herself invents a narrative that is not persuasive, it doesn't work. So, and I also, in part, I am sure the making up of the narrative involved is conscious, but in part it is not conscious, in part it is brought about by events and by relationships. I have identified, following actually a theory built upon Freud's theory of interpretation, 3 interpretive tools that figure as I argue, in constitutional identity making and changing. And those are the tools of negation, metaphor, and metonymy, which correspond in Freud to negation, then condensation and displacement. But the literary interpretive theory is broader and affords a richer way to look at this. So if you take, for instance, the French Revolution and the constitutional efforts right at the end of the revolution, the first thing they had to do was to dismantle the Ancien Régime. You had to negate it. Their scholars have spoken about creation ex nihilo of this kind of revolutionary constitution. And if you look closely, however, if you just throw out the past, you're left with nothing, or you're left with very little. You can't run, of course, you could run a purely descriptive definition of separation of powers. The president can do this, the parliament can do that, judges can do this, but that never works unless it's in a background in some kind of common understanding of functions, drawing lines, etc., etc. So the French Revolution throws out the monarchy and its institutions, but it remains French, which means that it has to reincorporate some things about the French past. It speaks in very abstract terms, of course. It speaks about the rights of man and citizen, and not about the rights of Frenchmen and French citizens. But even though it has universalistic aspirations, it does ground itself in connection with, by the way, at the time, developing national identity. Only about 50% of people in France spoke French at the time of the French Revolution, and there were some bloody incidents to try to convert people to speak French. But nonetheless, the French nation was emerging. The French state had been established by Louis XIV, and the Constitution after the Revolution had to somehow integrate many things. It didn't work for very well or for very long. France had then Napoleon, et cetera, but the first effort right after the revolution, or in the course of the revolution, was based in negation and in redefining many things. Now, if you take the American situation, you have also an overthrow of obviously the British monarchy and of the colony. The American Revolution, by the way, was not really a revolution. It's better described as a war of liberation. Then it's true that they reincorporated a lot of aspects of British law within the American Constitution. The notion of due process of law, for instance, was certainly very well grounded in the common law, but at the same time, they made a lot of they had a lot of parts of the Constitution that were directly contrary to the British, forbidding the use of titles of nobility, for example, making sure that everybody, notwithstanding what Trump said a lot of times, no one is above the law, et cetera, et cetera. Now, in order to focus on identity, I use the example of we the people. Because the Constitution, and then I'll relate it to the Hungarian 2012 shift from the Constitution of the people of Hungary, which preceded 2012, and the Constitution of the Hungarian nation, because those are two very different concepts, as I interpret them as a foreigner looking at it from afar. And so the we the people, interestingly, the American we the people is an empty signifier. If you try to look at the details, the people who gave the United States the Constitution were 55 propertied white men. The rest of the white population was not included. No women were included. There was slavery. So the American Constitution, which is at least by Americans touted as the most extraordinary document in the world, is in effect a charter that enshrines slavery and therefore contradicts the very essence of liberal constitutionalism. That flaw was corrected eventually. The same with respect to women. Both the French and the American constitutions, do they exclude women as the people? Who is the people? It's interesting that when you speak about the nation and the people are connected, when you speak about the nation, we usually do not find it difficult to define a nation versus another. If I speak of the German nation, I don't think I would mention Robespierre, and the American nation is different than the Japanese nation. And I think that if we look at all the elements that go into self-defining a nation as a form of imagined community, we can make clear distinctions. And by the way, in most cases, this has little or nothing to do with the Constitution. One can imagine French history or German history or Spanish history, even if they never had a constitution in the modern liberal sense of the term. So these are constructs. There is some relationship between national identity and constitutional identity, but the American we the people is a mystery. If you look at the we the people from today backwards, the we the people declared at the time have nothing to do with we the people today, because America is a land of immigration that has shifted enormously and so forth and so on. So this is the general problem. And now let me zero on my concern today, which is the liberal democratic versus populist. The liberal democratic identity making uses the same tools as populist identity making. But the key distinction that I found between the two is that there has to be a reconciliation within the liberal democratic vision between various component parts within the society, and to do so that there is some sufficient coherent narrative between individual interests, plural interests, different groups within society, and what I call the community of communities, which is the constitutional unit. And that doesn't mean that actual constitutions don't fail, but even if we obviously speak about after the Civil War and after women got the vote in the United States, even with all its flaws, the narrative about the American Constitution is that everybody is included. And everybody's included. The Constitution has been attacked from many points of view. It's been attacked from the left, it's been attacked from the right. It has its flaws, etc. But that's the thrust, that's the effort to try to unify on some level. Now, the unification is made, and this is where the discourse methodology is the same between liberal and populist constitutions, is made by using the same interpretive tools. So we have to draw distinctions, and we have to also have nodes of common identity. The Constitution is not fixed. I use a notion that is developed in a book by Paul Ricoeur, the French philosopher, which is identity as being either a question of sameness. I'm the same person I was yesterday when I look on myself in the mirror, but I'm certainly not the same person I was 40 years ago. Yet the second meaning is that of selfhood. So you have to construct a narrative of selfhood that may include, in the French case, the revolution, but you have to then incorporate all things in the new. The great authors of the Louis XIV, Racine, Molière, etc., are part of the French national identity, and you have to reconcile these people from different periods. So you reconstruct the narrative so as to try to keep things together. Now, of course, exclusion within a liberal democratic constitution doesn't mean excluding any of those fundamental parts of the society that ought to be constitutionally acknowledged. But it could be exclusion vis-a-vis outsiders. It could be exclusion vis-a-vis ideological positions or political positions that are not constitutionally protected, et cetera, et cetera. Populism is, on the other hand, uses the same tools, but does so for purposes of exclusion, because populism, and I'm going to focus on populism on the right. Populism on the left does not necessarily follow this, so I will focus only on populism on the right. The idea of populism is that the people, what is the people, which was very flexible in the United States and malleable and all these ideas melting. And again, you can criticize and say it's hypocritical, the ideology doesn't match the reality and so forth, but it's inclusive in its conception, whereas the populist conception of the people is always exclusionary. It could be the people versus the elites. It can be an ethnic group versus others. It could be a religious group against others. So you have to reformulate the identity, the constitutional and perhaps national too, but I focus on the constitutional identity. And I take first an example. I don't want to speak too long, so let me very quickly go through this. First, I take an example in the United States. Trump was an example. He didn't succeed. The reason I go to Orban, although it's more dangerous for me to speak of Orban than Trump, because Trump is internal matter. In the Trump case, he was not able to change the Constitution. But his idea was, he started his campaign by saying that Mexican immigrants are basically all criminals. Now, there is a large population of Mexican American and people of Spanish language origin, Latin American origin in the United States that immediately alienated that group. Then he went, his first executive order was a Muslim ban, where he said that Islam hates us and no Muslim, I'm paraphrasing, this is not exactly his words, but it's very close to his words, and Muslims hate the United States. They're incompatible with American democracy. But that's not all. He then went to say that the press is the enemy of the people. American constitutional identity, if there's one, I think, principle in American constitutional identity that nobody would dispute, is Americans' love, or somebody can say obsession, with free speech. If you ask an American, what's most wonderful about the United States? We have free speech. So free speech implies freedom of the press. So he's going against freedom of the press, so you'll have to redefine, if you ever translate that into a constitutional project, to redefine how do we make the press the enemy of the people. Another constitutional identity element, which is not inscribed in the Constitution, by the way, is that Americans, by and large, accept that we are a two-party country, mainly a two-party country. There are third parties here and there and so forth. And so, and American democracy depends on a healthy competition between the two parties. Trump has called the Democrats un-American and has said whatever policy they may engage in will destroy the United States. Again, he would have to change the Constitution this way. So let's go to a fellow who did change the Constitution for his country from a liberal constitution to a illiberal one, and that's Viktor Orban in Hungary. And in this sense, the comparison between Hungary and Poland is quite interesting, because the Poles made many of the same moves vis-a-vis the judiciary, for instance, but did not have the power to change the constitution. So the ruling party in Poland had to either violate the constitution or not. And here, before I conclude by trying to show the differences, let me just make a footnote. I trust two scholars from the area, András Schreier in Hungary and Wojciech Sadurski in Poland, and they both deny that either country really has a democracy going. They think that the moves made by Orban in Hungary and by Law and Justice in Poland are really, Kaczynski in Poland, are really moves to authoritarian illiberalism, and that the constitutional discourse is a facade. Let me leave that aside, because we do have a constitutional identity change that's quite remarkable in Hungary. So what does Orban do? In the simple move, and my paper is more detailed, but I'll make it short here. The simple move to go from, and you may tell me, Dr. Dinosky, that I don't read Hungarian, so maybe the English translation is not accurate, but from the English translation, the Constitution of the People of Hungary, which ironically was the communist 1949 constitution that after 1989 was changed, I understand, in every provision except that Budapest is the capital of Hungary. That liberal constitution for the people of Hungary turns into the constitution of the Hungarian nation. The Hungarian nation in the Hungarian context means ethnic Hungarians, which means, and the Constitution is clear about this, that the political sphere admits non-Hungarian nationals who live in Hungary, for instance, Jews and Roma, but they're not first-class citizens anymore because it's not their constitution, even though they have a position within the state and within politics. So this is immediately a distortion. There's another side, which is now that we see what Putin is doing, I'm very happy that Orban does not have the military wherewithal of Putin, of the dream of the greater Hungary, which was the one that was destroyed after World War I, the Austro-Hungarian Empire. And there are ethnic Hungarians in Romania, in Serbia, in Slovakia. And so it's an idea of, and what Orban has done, which is peaceful, but to say, you're all invited as citizens of the Hungarian nation to reintegrate with us. Now, some people have taken umbrage of that because they see that as a threat to the neighboring countries. Other people can just see that as an invitation of immigration. I don't want to accuse Orban of trying to start a war, but this changes, how do you assess the role of international tribunals? I can't answer the question. I'll try to answer it afterwards. So the point being that there is a transformation here of who is we the people. That's the first thing. The second thing I'll say just very quickly is the history of how Orban has used the history of Hungary by eliminating two periods of occupation. The first one being the Ottoman Empire from sometime the 16th century to the end of 17th century, and then the Soviet occupation. Now, interestingly, this is a nice move, but it has all kinds of implications because he alludes to Christianity as which is interesting because at the same time that he's fighting the European Union and saying that the European Union is Western, a European ideology, which is capitalism and selfish appropriation versus family values, Christianity, and all the wonderful things that he is exalting for his people, he uses the Christian symbol as a way to negate liberal cosmopolitan points of view, to negate the possibility of Muslim immigration, including refusing in a very dramatic way Syrian refugees. And he uses the European Union as a villain, yet at the same time, he fills his pocket with European Union money. I see now things may be getting a little more difficult for him, but for a long time it worked. And that allows him to keep his basic system, which is a plutocracy, where his friends get all the advantages and he stays in power by using this discourse. So there's a double meaning of Christianity. As commentators have said, Orban is a good traditional atheist who has embraced Christianity to try to get the kind of carving out of a constitutional system so as to further his aim. So he's blocking the Muslims, he's blocking the cosmopolitan elites who are presumably atheistic or agnostic. He is a nationalist of Hungarian nationals but is very much a European, although he refers to the first king of Hungary, the Saint Stephen of the year 1000, and sees a continuity. So he's a European Christian against the European Union. He is a Democrat constitutionalist, but he goes against all these liberal ideas. And the point is, I have not proven, and my paper doesn't, that you cannot have an illiberal populist constitution, but you cannot have a populist constitutional identity that is consistent with the main tenets of constitutionalism, because those you exclude cannot benefit within the entire society. Now, the last point I want to make is that, of course, if you look at constitutions that make it within the liberal frame, I'll use just the example of Greece. Greece favors constitutionally, officially, the state religion. The reason, so it's exclusionary. There is a favoritism in Greece for Greek Orthodox religion and for the hierarchy of the church, the Greek Church, to the detriment of other religions, or to the detriment, if you wish, of non-religious people. However, the Greek constitution is not exclusionary in the sense in which the populist constitution is. It tolerates sufficiently, from the point of view of liberty of religion, those who are not favored. So it's maybe more borderline than, let's say, the British constitution, which also has an official religion, but which uses it purely for ceremonial purposes and has one of the broadest religious liberties known to any government. So that is my conclusion, namely that right-wing populism cannot have a constitutional identity that works if you buy into the four pillars of constitutional order that I have mentioned before. Thank you.
Thank you very much. I completely agree with your conclusion. I will just have some comments on how you get there. But first, I would like to invite Professor Faraguna for his comments. Thank you.
Thank you very much, Tina. Thank you. Thanks to all the organizers and to the colleagues who presented their papers and their idea before. It is a big honor and privilege to comment on these papers and on these presentations. And I'm very thankful because authors circulated in advance some draft papers, and these draft papers were incredibly dense. And we know that these authors devoted a significant part of their scholarly work to study these topics, and I think that their papers were really like dense abstract of a very long scholarly journey, and so it is therefore an even bigger challenge to try to comment on their ideas because of this density. So it is almost impossible for me to comment. I have many comments on the specific points, but it is almost impossible to deal in such a way. And I know maybe it's not exactly the best way of performing the role of a discussant, but I will enter in the seminar by discussing their ideas as a whole, and then maybe the Q&A we can add just specific points, because I would be very interested in that. So this is a truly global seminar. I think we can stay there, and in this truly global seminar, I would like to offer a European perspective. And this is not only a statement to justify my presence here at midnight, but it is certainly also not a critical take on the presentations. On the contrary, I think that both Cólon-Rios and Rosenfeld took into great consideration latest European developments. And I think, I mean, it is not a gesture of Eurocentrism to identify a very specific and a peculiar characterization of this debate, a Sonderweg, we could say, in the construction of the concept of constitutional identity in recent European perspective. So I will take up Tima invitation to offer also a supranational perspective in the investigation of this topic. So the point is that what are the reasons justifying this peculiar debate and this peculiar Sonderweg in Europe? And I think one of the reasons justifying this is that the European Union law has an identity clause, and this is something rather unique. So the EU has an identity clause, as the EU, in my opinion, needs an identity clause, and it needs one because Europe is a very small continent with very deep legal integration and a large legal heterogeneity. So, as it always or maybe often happens, and both papers brightly illustrate this phenomenon, constitutional law often follow history, and history often follow politics, while politics follows society. So therefore, I think that an historical perspective may be a rather illuminating one in the analysis of the concept of constitutional identity from a European perspective, but probably from a universal perspective. So in this sense, constitutional identity was born in EU law as a mere political statement in 1992, included in the Maastricht Treaty in order to reassure some member states, both political actors and judicial actors, about their concern of giving up their role as guardians of statehood and guardians of a pluralistic, democratic, and liberal constitutional order. So for some decades after 1992, the identity clause and the identity arguments did not emerge expressly in the judicial dialogue engaged in the European Union and in the jurisprudence of the Court of Justice of the European Union. The situation has changed both in the treaties and in the legal consequences after the reformulation of this identity clause with the Treaty of Lisbon in 1929, with the constitutionalization of the identity clause and the subjection of this clause under the jurisdiction of the Court of Justice of the European Union. Nonetheless, the impact of this new formulation from a political statement to a properly legal and namely constitutional provision was rather limited if we consider only the case law of the Court of Justice. So the clause made it into the legal reasoning of some decisions of the Court of Justice. However, the number of cases is rather limited, and in my opinion, their constitutional tone is rather poor. Yes, it's true that a different trend is emerging very recently. For example, in the twin decisions of the Court of Justice on the conditionality mechanism issued in last February, and in one decision concerning the independence of judiciary in Romania, and one opinion of the Advocate General Emiliu in a case submitted by another member state's constitutional court, the Latvian one. Both these decisions, these acts issued last March. But here it is true that here the Court of Justice pushed itself a bit more on the ground of interpreting member states' constitutional identity. However, in my opinion, this trend is not established yet, and it is too soon to recognize a paradigm shift. And in my opinion, we could say that the court's self-restraint on the territory of member states' constitutional identity is still the dominant approach. On a completely different front yet, the constitutionalization of the identity clause provided for by the Treaty of Lisbon had a much higher impact on the case law of the member states' constitutional courts. We can mention a number of cases where national constitutional and Supreme Court opposed some sort of constitutional reservations to the principle of primacy of EU law, and this number of cases significantly increased after 2009. Many of them are well known in the scholarly community, the case of the so-called Slovak pension, then the German sagas, OMT, the Weiss saga, the European arrest warrant decision, the Italian saga in the Taricco case, and of course the mentioned decision of the Hungarian Constitutional Court in 2016, and a recent decision of the Polish Constitutional Tribunal in 2021. So all these decisions reveal a trend of an increasing use of identity-related arguments in the legal reasoning of national constitutional courts. The problem, so to say, if this is a problem, is that along with an increasing use of constitutional identity arguments, there is also an increasing abuse of these arguments. And the abuse of the notion was very clearly illustrated in the presentation of Michel Rosenfeld just like a few minutes ago. The brightest example is probably the infamous decision of the Hungarian Constitutional Court, where the court assisted the Orban government in affirming with a, in my opinion, rather sophisticated decision from a legal perspective, that the EU policy of assigning quotas in the relocation of migrants consisted in a violation of Hungarian constitutional identity. But we may have other examples also by political actors, particularly in Poland, where identity arguments were abused in similar terms. So abuses of identity-related arguments led some scholars to advocate the lack of utility of the notion, the dangers of the notion, and so some scholars demanded even that member states engaging constitutional identity talks should not take part to the EU legal integration at all and leave the union entirely, and so on. So my personal view is that abandoning the notion of constitutional identity because of its recent abuses is far from a wise option. So first of all, in my opinion, constitutional identity is now a matter of black letter EU law. Article 4, paragraph 2 of the treaty is part of the treaties, and it is also subject to the jurisdiction of the Court of Justice. So a treaty reform providing for the abrogation of Article 4.2 is a completely unrealistic scenario, and therefore I think that as lawyers we should acknowledge that constitutional identity exists as a legal notion, and so we should make use of that. Second, advancing a sort of, let's say, theoretical abjuration of identity just because of the risks coming from abuses is, in my opinion, counterproductive and more dangerous than the dangers that this strategy aims at neutralizing. So in my view, there is a much more effective and simple alternative, and this alternative is acknowledging the legal success of the process of legalization, positivization, constitutionalization of the identity clause in supranational term, and focusing on abuses and misuses of this notion. So to a certain extent, in my opinion, the same fact that the clause is increasingly more and more subject to abusive manipulation is a clear symptom of its success. So the same is true for many other key concepts of public law, such as democracy, freedom, liberalism. These are all indeterminate, and as such they are and have been prone to abusive misinterpretations. And this is not a reason to say, okay, let's throw liberalism, freedom, democracy to the bin. So maybe someone would think that, but I mean, I think this is not a mainstream take. So the destructive potential of constitutional identity, in my opinion, is not an essential character of constitutional identity per se, but it is a possible consequence of its abuse. So the challenge is then recognizes the abuses and building legal remedies against them. As legal scholars, I think that we can have some responsibility on both fronts. And on the first front, I think that Cólon-Rios' approach seems very promising and very convincing to me. So constitutional identity has both a descriptive and normative dimension. All constitutional polities have a constitutional identity in the descriptive sense, while in normative terms, not all constitutional identities are to be protected from the perspective of constitutionalism based on the 4 pillars mentioned by Michel Rosenfeld. So we could say that constitutional identity should be respected as far as they are constitutional and not unconstitutional constitutional identities. And so keeping puns aside, respecting constitutional identity is nowadays a matter of black letter fundamental principle of EU law that should be nonetheless balanced with other fundamental principles of the EU. And among these, the fundamental principles mentioned in Article 2 of the same treaty on the European Union are certainly to be included as counterbalancing principles, and they are also core principles identifying the European Union constitutional identity. Article 2 and Article 4, paragraph 2 are on the same level, and therefore claiming that the identity clause protects a national measure that violates the principles protected by Article 2 should be recognized, in my opinion, as an abusive application of the identity clause. And this is what the European Court of Justice recently started to affirm in clear terms in the Twins decision last February, and reiterated in this less known but no less important recent opinion by the Advocate General Emilio in March 2022, 1 month ago, more or less. So, if an identity is to be constitutional, it needs to refer to specific principles of a given constitution of a specific member state, but also to the principle attaining at having a constitutional in general, based on the 4 pillars mentioned by Michel Rosenfeld. So this normative conception is gaining ground, in my opinion, in the European discourse, and it is also generating some positive side effects. So the rejection of unconstitutional constitutional identity is slowly leading to an affirmation of a European constitutional identity, and this is a relatively overlooked topic that I think needs to be theoretically framed and strongly affirmed in the European legal scholarship. And this is what also Timea and I have recently tried to do in a co-author paper, and now I'm now advertising without her consent. So this were my takes on this point, and thank you very much for your invitation once again.
Thank you so much. And as a moderator now, I would like to abuse my possibility to speak a little bit. I would like to make, I think, 3 points very briefly. And then I would have, I think, 2 questions. So first, Professor Rosenfeld, the translation, when I read your paper, I had to actually open the English and the Hungarian version of the fundamental law, because I couldn't remember. And then there are some things which the word people appears in the Hungarian version in the preamble part, but then it is translated into nation. So that I haven't checked the entire text, but there could be, yes, things which have not been like properly translated, and that could cause confusion. Also, the use of these terms, and I don't think that anybody in Hungary believes that the drafter of the fundamental law actually thought about these niceties of the terms. So you probably know that there is this story that the fundamental law was written on a train, by a person who was like actually traveling. So there were no really sophisticated understanding maybe of these terms, the use of nation or the people. I checked also the Constitution, which is the 1989-1990 version, the liberal Constitution. And I'm not sure that it is actually taught for the people or used that we the people. And that is also confusing, because both the Constitution and the fundamental law originates the public power in the people. So I don't know whether it makes any difference for you, but I think when we are talking about maybe like negation, we have to negate something. But now, if the Constitution didn't use the people, how we can use this, the first part of identity creation? But I'm completely agree with your conclusion. Actually, as I said, I just have some not even problem, but I think that is a translation issue mainly. The second point, you mentioned also that Orban uses the history very cleverly, and that is actually true. It is very concerning, and which is concerning is that they, I don't know whether there were actually really researched understanding of what the historical constitution is when they put it into the fundamental law. But they now it is linked to, as Professor Cólon-Rios mentioned, it is linked to the historical constitution. So now it is in the constitution in Hungary that our constitutional identity is rooted in the historical constitution. And that is very confusing because we don't know what the historical constitution really is. It is for historians to come up with this idea. And there are like debates about when it started, when it ended. And so it comes to the Ottoman Empire. So whether we had a historical constitution which was like suspended, but that sentence refers to that the suspension of the totalitarian that we deny the legality or validity of the oppressive powers, whether it indeed relates to the Ottoman Empire or not, because then it would mean that we had historical constitution. But when the scholars were talking about historical constitution of Hungary, it was only in the 19th century when they started to conceptualize the term. So this is very confusing when you put something into the constitution which is not a legal term actually. And it indeed would bring, for me, not a conservative understanding of the identity of historical, but even a liberal understanding. And also, I completely agree, and this is already the third point, that it is very exclusive. So there is exclusion, that is for sure. But I would personally, I would put the emphasis somewhere else and for different reasons. And for this, I would, I will not explain it. I would have a question for Professor Rosenfeld. So in your paper, there is a sentence that constitutional identity-based exclusion seems potentially more pernicious than exclusion within the constitution itself. I'm not entirely sure that I understand here what you mean, because in the paper and in your presentation, you based your argument on the constitutional text. So what is then the difference between the constitutional identity and when it is exclusive, and then the exclusion within the constitution itself? I completely agree that if we have a look at Hungary, exclusion is there, yes, and it reflects in the constitutional identity. As you also said, that the narrative needs to work, and I think that it is working in Hungary, unfortunately. And what was this chicken egg issue? What was before, right? And I afraid that the need for this kind of narrative was already there. Otherwise, the narrative couldn't be working. And yes, and thank you so much. And Professor Faraguna, thank you. The advertisement, it's very important. And it's always a pleasure to work with you. So, and sorry, one other, a little bit of explanation on this historical constitution issue and Hungary. So now, the historical constitution, we have like several definitions on that, and it also includes some extrajudicial elements in the works of the public law, constitutional law scholars, for instance, in the interwar period, and it is also connected to our so-called doctrine of the Holy Crown, which actually this text, this expression also appears in the fundamental law, even though we are not a monarchy. But so here the issue is that I'm not really sure. I understand what Professor Cólon-Rios is when he was like talking about that historical constitution has a kind of refusal, the idea of refusal of constituent power. Now in Hungary, the idea of historical constitution and the doctrine of Holy Crown is about the source of power, and the constituent power of constituent elements of this Holy Crown or the king, the territory of Hungary, and the nobles. And so they were subjected, how the king could exercise the power, it was subject to the national sovereignty, in which the nobles, like the people at that time, were part. And so it is, I think, that's a kind of different interpretation of historical constitution. And what is scary is that this kind of interpretation or using of the idea of historical constitution connected to the history and the narrative of history is that it has appeared in one of the dissenting opinions of the Constitutional Court, which says that the historical constitution in Hungary, in which our identity is based, it has never been used against the status quo, historically speaking, but it was always used used against the integration into the Habsburg Empire. So here comes the judge in the Constitutional Court that maybe the achievements of the historical constitution should be activated against the actions of the EU and other powers. And just 2 years later of these dissenting opinions, dissenting opinion that appeared in one of the decisions, the Constitutional Court of Hungary says that the protection of the inalienable right of Hungary to determine its territorial unity, population, and the form of government and state structure forms part of its constitutional identity. So it seems that that there is a parallel between the elements of our historical constitution and the actual constitutional identity of Hungary in 2022. So I really appreciated your, Professor Cólon-Rios, your parallel between the identity and historical constitution, because at least in Hungary, this is a very actual and very important discussion. So yes, thank you so much. And sorry for, again, talking too much.
Yeah, maybe we should receive some feedback from Professors Rosenfeld and Cólon-Rios on what Timia and Pietro just commented, and in some cases made some questions.
I obviously do not read Hungarian, so I am at a disadvantage, in which I acknowledge. What is, however, remarkable to me is not exactly what was written or said. We're talking about building a narrative, and the narrative seems to mirror the policies and the ideology. We in the United States may be very smug, and maybe the French are too, because we escaped, those of us who thought that Trump was a constitutional disaster, escaped the consequences of his views, thanks to the fact that Biden was elected, who is a traditional, whatever faults he may have, he's a traditional liberal Democrat who basically believes in adhering to the rule of law. But if we imagine, which is not far-fetched, that Trump wins in 2024 and has enough of a majority to make constitutional changes, either which he may be doing in any event through his Supreme Court, but more radically through some kind of more amendments or so forth of the Constitution, there would have to be a redefinition of the narrative. This also allows me to very briefly comment on Pietro Faraguna's excellent presentation, and that is that there is a technical sense now in the European Union of constitutional identity, and discussing this, for instance, with French scholars, what they consider French constitutional identity is the sovereignty and the idea of French independence as a nation state that shouldn't be infringed upon by the European Union. There is the whole idea that since so long that the nation states may rebel against the European law by putting their constitution on top of it. So in this technical sense, it's a question of adjusting. It's sort of, from an American point of view, a quasi-federalistic type of way of looking at things. What can the European Union impose on the populations of the various member states, and what can be protected against it? In this technical sense, this has now become a legal doctrine with judicial decisions, and we have to deal with it. And I completely agree with the conclusion of Pietro Faraguna, which is that it makes no sense to throw it out, but we have to live with it, with its faults and with its conflicts. Now, when I talk about constitutional identity, I'm looking beneath the surface anyhow. And to give you just one last example, it has been analyzed that the freedom of speech provisions of 40 different countries sound more or less the same. Yet in some countries, you can go to jail for 15 years for criticizing the government. In another country like the United States, you can engage in hate speech to your heart's content, and that's constitutionally protected. What accounts for that? It's not the words, it's not the concept itself, but it's how it's built in, how it is envisioned, and so forth and so on. So to finish my point, whatever the technicalities of the words in Hungary, whether it was written in a train late at night or not, there are things that I at least are not simply word translation, but entire concepts of thinking, for instance, of citizens within Hungary that are not Hungarian nationals, that have political rights and are recognized by the state, but it's not the blood life of the Constitution, to a person coming from a liberal constitutional point of view is quite surprising. So, and it accords with the ideology of the present regime. So this is how I look at it, more than technically, how did we get from this to there? Thank you.
Yes, thanks very much, Pietro and Timia, for those very interesting comments. I would say two things. So my first point would be that both in Pietro's presentation and also in Professor Rosenfeld's, there is this, I wouldn't say tension, but there's the question of what is the relationship between national identity and constitutional identity. And sometimes we talk about those things as if they were kind of the same thing. So for example, the identity clause of the Treaty of Lisbon, it doesn't say constitutional identity, it says national identity as reflected in the constitution, in the political structure or something like that. But yet people, I'm not very familiar with the debates in Europe, but I've seen many articles in which scholars refer to that identity clause as constitutional identity. And I wonder whether these are actually, what is the relationship between these things? And I think there's a distinction to be made. So so in both the at least that identity clause, the way I read it, not being an expert, it seems to be about how national identity is reflected in the Constitution. When I speak about constitutional identity, say in my presentation, I was talking about the identity of the Constitution. What are the defining attributes or the hardcore elements of the constitutions that if you change them, you would be actually creating a new constitution. Now, this is why I think, in a certain way, Professor Rosenfeld's presentation and my words, at one point, were just talking about different things, like different, really different kind of approaches, to the extent that it seemed that we were not talking about the same concept, constitutional identity. But of course, there is a place where these two, national identity as reflected in the Constitution and the identity of a constitution, they come together in the constitutional text. And so I think it is not, and I think it's understandable and it makes sense to speak of these two things, national identity and constitutional identity, as closely related. But I think somewhere there's a distinction that is sometimes obscured, and then and I think it's worthwhile to think more about what exactly the relationship between these two things is. And then Timia, yes, I ran a big risk, similarly to Professor Rosenfeld, I think, for a different nature, but when I when I talk about the historical constitution as a European doctrine and sort of try to suggest that the use of the phrase in Hungary has some sort of direct connection with that history, you know, that's a huge risk, because I have no idea whether the Hungarian constitution makers or the person who wrote those provisions was familiar or was somehow building on that old tradition of the historical constitution. Conceptually, nonetheless, I can see some similarities in the way, at least I have seen scholars writing about Hungary discussing that notion of the historical constitution. And one thing I would say, Timia, is that at least in England and Spain, when people talked about the historical constitution, they were also talking about the source of power, because the idea was, you know, what is the key element of the historical constitution? Well, that the crown in parliament is sovereign. You cannot change that. And the idea was, you can have different constitutional changes. You can, in fact, have many different written constitutions, but that historical constitution has to remain. If you sort of abolish the sovereignty of the crown in parliament, you would have, in fact, done something that should not have been done. So it's something like you would have replaced the constitutional identity. You would be sort of acting against history. You would be doing something that would result in instability and so on. And this was the point that, say, in Spain, the constitution, the critics of the constitution of 1812 made after that constitution was abrogated. So I think, yes, I think that would be my main two points.
Thank you very much. I would like to, if Pietro, you don't, or maybe you will. So as I said, even in in Hungarian, it's confusing. People, nation, national identity, constitutional identity, identity of the constitution. And yes, you are right. I think that there are like at least two understanding of national identity, or three understanding of national identity, depending on the context. So in the Treaty of European Union, as it was interpreted as a constitutional identity of the member states. And I'm not familiar with the how they actually discuss the term of national identity when they put it into Article 4.2. But I think that they use national because they refer to the member states. And that, or I don't know, Pietro, but what's your view on that? So that was only the reason, because now national identity also means that the identity when you create, as Professor Rosenfeld explained, during your nation state building activity, right? And then now you also mentioned that, yes, it's confusing, national identity, constitutional identity, what is what? And yes, and then constitutional identity, as you use, is descriptive and normative. I also use the term in one of my articles as identity of the constitution, as you mentioned. So when we are talking about how to amend, what not to amend, that is, and when you are talking about the eternity clause, that is could be like the identity of the constitution. It needs to have some connection with the constitutional identity as interpreted by Professor Rosenfeld and Professor Jacobson as well. And maybe I misunderstood them, but in that article, I tried to explain it mainly to myself, what those different concepts are, like constitutional identity, how they relate to the identity of the constitution, which you called the normative aspect of the constitution. And yeah, that would be Pietro. I don't know whether you have anything to add to this national identity, the term, to the treaty.
Yeah, I mean, I would not put it as simple as the fact that the word uses national is connected to the fact that they meant like national in the sense of a federal state, where national means to refers to the state level. Certainly, the point is that there is the interaction of two autonomously ambiguous terms. Constitutional can be an ambiguous adjective, and also national can be ambiguous. And of course, the definition of nation has to do with the constitution in many cases. And I think that according to the specific constitutional tradition, the definition of a nation can find in the constitutional source, the answer to find what a nation is, but while in other historical traditions, this is not completely true. So I would say that still, I mean, we need to overlap, but still, I mean, distinguish these two levels.
Yes, for sure. Thank you. And now I would like to invite Professor Rosenfeld to.
Just one clarification because of the discussion. Of course, words could be taken, it should be taken literally. The American constitutional identity is different than the Italian one because we have a presidential system, they have a parliamentary system. Okay, so in this sense, it's very obvious, and I don't think we should have a lot of controversy about it. But what I want to focus on is on the difference between national identity and constitutional identity. There are countries in which the Constitution, in part at least, goes against national identity. And examples of that are the countries, for instance, where there are some strong ethnic tensions as part of the national history and the national way of life. And the Constitution, for instance, prohibits political parties that have an ethnic base built. So you cannot have ethnic base. You cannot have the Turkish party in Bulgaria and the Christian Orthodox party. That is a constitutional identity move. And in order to interpret it and in order to make it live and working, you have to build some narrative that goes against the history, the tendency, etc. So that's why it's important to, even though there are certainly confluences and overlaps and confusions, the two concepts must be remain separate.
Thank you. Thank you so much for this clarification. And now I would like to invite you back to answer our question about international tribunals. Mateusz Buzaka asked this question in the chat. You are muted.
Question be repeated, please, because I saw it very quickly while I was talking,
yes.
So I don't remember it.
Yes, so Professor Rosenfeld, how do you assess the role of international tribunals in the construction of constitutional identity? Can the internationalization by states of the legal international discourse reinforce constitutional values and reconcile self and other by materially expanding the rights of groups that are in principle excluded from the constitutional identity?
Well, I think that international courts vary in what they're doing. There is clearly a debate about European constitutional identity, not in the technical sense of the Lisbon Treaty, but we had a discussion before the Lisbon Treaty in a large conference that we had on European Union. And that was, can the European Union, when the Constitution was alive, so this was a conference we had, I think, in 2004, before the French and the Dutch said no to the European Constitution Treaty. And some European scholars, in particular, I remember Armin von Bogdandi, tried to outline what is the constitutional identity of the European Union, and had a negative side, we're not American, and then had a positive side of the history of Europe, rejecting the totalitarian past, et cetera, et cetera. So that's one level. The other level is that there is a conception, for instance, of human rights. So the European Court of Human Rights or the Inter-American Court of Human Rights have an agenda. I am sure, I am not an expert, but I'm sure that if I were able to devote significant amount of time to see what emerges in the jurisprudence, I can have, it has a particular view of the human rights aspects of constitutions. How is it different than national ones? How does it incorporate national ones? How much does it defer to the margin of appreciation? We could go into a long discussion. So international tribunals affect, interact, but don't necessarily have a constitutional identity as such. Is human rights exclusivity a constitutional matter? Is it something we should take separately? Even though all constitutions that meet the four pillars have a human rights aspect. So these are very important, difficult questions that deserve further research. So I hope that the questioners would be interested in further researching that and enlightening us down the line.
Thank you so much. May I ask whether we have any more questions or other comments? Emilio?
Yes, very quickly, I would ask Joel about the difference between historical constitutions and national identity, but he just made his points, and I think that it was a very good explanation. So I would have just one question for Professor Rosenfeld. Your starting point is the difference between sameness, or the fact that we should consider that there is sameness and selfhood in the way by which Paul Ricoeur conceived of it. And one thing that I was wondering is if that when we are talking about authoritarian definitions of constitutional identity or populist definitions of constitutional identity, if the idea of sameness is the most important thing than the idea of a selfhood, because some of the studies that discuss authoritarian personality, they try to show how sameness, how oneness are some of the political features that create problems for those people that adopt an authoritarian way of seeing life as a whole, or political life as a whole. So my question is that is in that sense, shouldn't sameness be the most important thing when we're talking about this tension that creates the space for constitutional identity?
Thank you, Emilio. I'm just sorry, because I think that Emilio just asked two questions maybe, and we have another one. So if I just can read it, so that because it went to everybody. So Enrico Oliveira asks that national identity and changes in constituents with the people, it changes over time. In regards to the framework of a historical constitution, how could this be reconciled with abrupt cultural and or demographic changes? How could historical identity be preserved without veering into populism? So I think that it goes to everybody. Thank you. Now, Professor Rosenfeld.
Okay, didn't know if you wanted me to answer. So the question of, again, as an interpretive tool, sameness and selfhood, meaning try to identify poles of identity through very visible and indisputable change, are just tools to try to explain a position. Now, the authoritarian populist does not have to be at all concerned with what we understand as liberal constitutionalism. Part of populism is a charismatic leader who says that he embodies the destiny of those who count as the people. And so when you look at it this way, it's a quasi-religious bond. In a sense, and I mean, this idea, although this is not the way he put it, comes from the idea of Carl Schmitt that pluralism is inimical to his view of a constitutional order that should work, and that therefore it's better to have a dictator who understands the will of the people, meaning not those who want to belong but are not really part of the people, than a democratic election, because that's imperfect and you may get a leader that does not understand fully what the people want. So in this sense, it seems to me that the question of sameness and selfhood is just a rhetorical idea. How does Putin explain the czars all the way to the Soviet Union, to the fact that he wants to recreate the borders that existed before 1991? I can see many different ways of saying that, and I'm not sure which one of them works better with the Russian people, because I'm not an expert. But from the standpoint of my theory, that makes very little difference. Now, the second question, which I now forget, is one about the one that you read. I'm sorry, but I lost track as I was answering to the question by Emilio.
it asks whether
the changes in the
yes, about the abrupt cultural and democratic changes.
Okay.
Yes.
So let me give you a very American example that I think provides an answer. I mentioned the horrors of the Constitution where slavery was it had to be part of the deal, otherwise the Southern states would not have entered into the Constitution. And I want to refer to the 200th anniversary of the Constitution, 1987. And there was a national celebration. If you look at as I said, we the people and who had power in 1787, and then you look at 1987, where we absorbed a big population of people coming from many continents, et cetera, and officially everybody's an American. There was endless celebration where we congratulated ourselves as the greatest country in the world, the longest constitution. I'm sure you heard the propaganda, I don't have to repeat it. But there was one Black justice on the US Supreme Court named Thurgood Marshall, a very large figure in the history of the United States. And he said, I'm tired of these celebrations. To get here, we had to go through slavery. We had to go to a lot of massacres. We had to go to a civil war that was extremely bloody. We had to go to a period of segregation. And now in 1987, we're better off, but we still have a lot of racism. Two completely different views of the constitutional experience of the United States. Now, I don't think the United States could survive if the Marshall view, which was very sober, were the dominant and a constant reminder, because there is a historical grounding. There are people in the United States who are very big on originalism. What did the great founding fathers want? Which in a sense is absurd, because we had a constitutional revolution during the Civil War. We went from a slave constitution to a constitution that prohibits slavery. We had a change in federalism to try to abolish slavery and the remnants of slavery. So in effect, the United States has had at least two, maybe more constitutions from a substantive point of view, even though the text, interestingly enough, the text of the Constitution is not changed. The amendments are added later. We have not rewritten like Hungary did its constitution. We keep the same constitution with the provisions relating to slavery still in the constitution, still the text that every student must read, and yet we are at a very different place. So it's a question of a dynamic dialectic process whereby we have to explain to ourselves there's continuity, or there's progress, or there's revolution, and many forms of discourse can come into the final product.
Thank you. Professor Cólon-Rios?
Yeah, no, I think that was an excellent answer. I think that I'm happy with it.
You are very happy. Okay. Professor Faraguna, any views? I know it's very late there.
No, sorry, I had to move on the mobile phone because in a few minutes the building will be closing, and so I'm preparing myself in case to be connected. But yeah, I mean, I don't think that questions were referred to comments, so I could follow Joel's satisfaction.
Okay, thank you. I think that I can say that I'm also very happy and satisfied with today's session. I learned a lot. Thank you so much for coming and talking. I think that we had a great discussion from different perspectives and viewpoints from, I mean, basically all around the world at this point. Thank you so much, and good morning, good night, good afternoon to everybody. Bye.
Again, thank you so much, Professor Cólon-Rios and Professor Rosenfeld, and also Professor Pietro. It was a really good event with very good lectures. So thank you so much on behalf of our university here in Brazil.
Thanks to you. Thanks very much.
Thanks to you.